seated. My understanding, we have a verdict? Yes, you bring them. I understand that you have a verdict. Will you hand it to the court deputy, please?
In the circuit court of the 9th Judicial Circuit in Orange County, Florida, case number 2013 CF 3900, the state of Florida versus Daniel Anthony Saylor Perjury. Verdict: we, the jury, find the defendant guilty as charged in the information, perjury, and official capital proceeding, so family-dated at Orlando, Orange County, Florida, on this 22nd day of January 2014.
Does either the state or the defense wish to have the jury polled?
Yes, Your Honor, please.
Juror in seat number 1, is this your true and correct verdict? And juror in seat number 2, is this your true and correct verdict? Juror in seat number 3, is this your true and correct verdict? Yes. Juror in seat number 4, is this your true and correct verdict? Yes. Juror in seat number 5, is this your true and correct verdict?
Yes.
Juror in seat number 6, is this your true and correct verdict?
Yes.
I want to thank you again for your time and consideration of this case. I also wish to tell you some special privileges enjoyed by jurors. No juror can ever be required to talk about what happened in the jury room except by court order. For many years, we have relied upon jurors for consideration of difficult cases. Therefore, the law gives you this unique privilege not to talk about your votes, your discussions, your deliberations for as long as you wish it. You're now free to speak with anyone you'd like about this case. You're also free to refuse to speak with anyone. It's completely up to you individually. With that, you can follow the deputy out. You may be seated. Any legal reason we cannot proceed to sentencing?
No, Your Honor.
State argument as to sentencing.
I do have a score sheet if I could approach, Your Honor.
You may. Defense, do you wish to handle the VOP at the same time?
Yes, Your Honor.
Then CF 11518. Mr. Saylor, you're still under oath. Is it true that you were in fact on probation for 4 counts? Official misconduct, solicitation for official misconduct, and tampering with evidence? Is that true?
Yes, ma'am. Yes, sir.
Were you in fact placed on probation on June 30th, 2012?
Yes, ma'am.
Finding that, I will find that your admission is on that particular issue and find that there is a violation as to violation of condition 5.
And Your Honor, just for record purposes, for the purpose of the violation of probation, we would object to the same evidentiary issues that we did in the trial.
Understand, thank you. State argument?
Yes, Your Honor. The defendant has been found guilty of perjury. I know Your Honor heard the testimony over the course of the last day and a half. The state believes that, well, not statutory aggravators, the factual aggravators in this case are the nature of the proceeding, not only the fact that it was designated by the legislature as a capital case, but that there were 2 young victims involved who did testify. And as I stated in closing arguments, I don't believe there's any other way to read Mr. Saylor's testimony other than it was designed to impact their credibility before the jury. Thankfully, the jury found Mr. Bush guilty in that case. To compound that, you have the fact that he was in law enforcement for many years, and as he admitted on the stand, was very aware of his duty and oath to tell the truth, not only as a law enforcement officer, but especially when testifying before this court. And finally, as Your Honor just noted, for the record, he was on probation to boot when he made these statements. So I will leave it by saying that Your Honor knows that every day we do criminal cases in this courthouse. And if people do not tell the truth, then the system of justice we have will not work. It's impossible. Mr. Saylor knew that, and regardless of that fact, in all his years of experience, he got on the stand and told a lie. I'm not going to make a formal recommendation as to the years. Your Honor has a score sheet in front of you. You know what he scores. The state would just ask that Your Honor weigh the testimony and evidence in this case and render an appropriate sentence.
Thank you. Defense argument.
Mr. Chairman, I'd like to address the court to the sentence.
Yeah. Go ahead. Your Honor, I don't really know what to say to you. I still believe what I said was the truth. I'm a single father with a daughter. I've served my country in the state of Florida for many years, and I find myself in this position now. I don't know what to say to Your Honor. Please have mercy on me.
All right, on that. Judge, if I just have a moment.
I can't hear you.
Your Honor, just briefly, I have reviewed the score sheet. We have no additional deletions or corrections to make to it. I always think it's difficult, Your Honor, when there are witnesses who testify in court, and cases like this would seem to stifle certain witnesses from testifying in cases because of the ramifications of that testimony. The court will call the evidence from the Bush case in 2003, which was the basis of this statement. There was no evidence that Natasha Bush had ever made any sort of allegation of a sexual abuse. That didn't occur in 2009. I believe the state's position that somehow this affected whatever the outcome of the case in regards to Natasha Bush isn't true based on the fact that there was no such evidence back in 2003. I understand that Mr. Saylor was convicted here today. We would ask the court to follow the guidelines in sentencing Mr. Saylor and give him a concurrent sentence on violation of probation.
CF 133900, the court will adjudicate you guilty as the jury found you to be guilty, sentence you to 8 years Department of Corrections credit for 13 days that you served. In CF 1151A, as to the 4 counts, the court will adjudicate you guilty, will revoke and terminate your probation. In each of those counts, will sentence you to a 4-year Department of Corrections sentence. Each count to run concurrently, in each case to run concurrently. That's credit for 15 days that you served. Because all the statutory court cost fees, cost of prosecution, those amounts of money will be sent to collections court for you to start making payments within 180 days of your release from custody, no less than $30 a month until it's paid off. You have 30 days in which to appeal the judgment and sentence. If you cannot afford an attorney will be appointed to represent you, and the appeal has to be in writing in those 30 days. Do you understand that, sir?
I don't understand how many years I got, Your Honor.
8 years total. It's 4 years concurrent on the violation of probation.
Your Honor, as for the credit for time served in violation of probation, it's my understanding that you had served a year in jail in that matter.
Is that your understanding, State?
Yes, I believe the sentence was 51 weeks work release, is my understanding.
And that should be 51 weeks and 15 days. That's not showing. Thank you.
Thank you, Your Honor.
Good luck to you, sir. We'll be in recess.
Love you, Ted. Love you, Mom.